Hello and welcome to Reasoned UK. Please do consider hitting that subscribe button and the notification bell to make sure that you don't miss out on any future content. Now, last week, as you might be aware, the government's online safety bill was taken off its leash. Described as a world first, the bill purports to be there to protect children, consumers, and speech. The Secretary of State at the Department of Culture, Media and Sport, Nadine Dorries, said that the absolute priority of the 225-page bill is protecting children and the vulnerable from harm. Now, I'm delighted to say that I'm joined today by Victoria Hewson, Head of Regulatory Affairs at the Institute of Economic Affairs. She's poured through all of those 225 pages that I mentioned of this bill to tell us why she's seriously concerned by its contents and the consequences of its contents. Hello, Victoria.
Hello, Darren.
Now, Victoria, can I start by asking, most people, right, will hear laudable sounding statements about forcing tech giants to remove illegal content such as child sexual abuse, for example, and things like terrorism and all these other things. They're surely worthwhile endeavours, right? Most people would say, well, hang on a minute, Victoria, what have you got against this?
I think you will struggle to find anyone, even amongst the libertarians at the IEA, who would have any trouble whatsoever with tech giants, social media platforms, search engines, whatever it is, removing content that is aggressively illegal and harmful, like the examples you mentioned, child sexual exploitation, material that's used to facilitate and carry out terrorism. The problem is that the bill put forward last week doesn't stop there, and it includes multi-layered, highly complex duties to filter, minimize, remove content that constitutes an offence, or indeed that simply is designated by the Secretary of State in power at the time as being harmful. Mm-hmm. And of course, the problem is that in the normal course of the offline world, when police investigate a criminal offence, the Crime Prosecution Service will advise on whether the burden of proof has been reached, as to whether it's worth pursuing the offence in court. And then the courts will look at the whole context of what's happened. They will take into account freedom of expression in determining whether an offence has actually been committed. For Facebook and Google and all of the other thousands of social media and online platforms concerned, they won't be able to do that. They will just have millions and millions of items of content and a strong incentive to remove first and ask questions later.
On the point about so-called misinformation, right? How do you define misinformation? If you consider that at the start of the pandemic, right, advocating mask wearing would have been deemed disinformation against public health, or saying that homosexuality wasn't a mental illness in the early 90s, where Facebook and Twitter to have been around then, isn't much that's classified as or classed as disinformation simply just dissenting speech and debate? Won't this actually stifle speech and debate online?
Well, let's take a step back to begin with and work out where this bill is going to bite on disinformation, because that's quite an interesting question.
Yeah.
Now, there isn't at present a specific duty that bites on platforms and search engines to remove and minimize or filter disinformation as such. However, there is going to be a power for the Secretary of State to designate certain content as priority content that is harmful to adults. It's a catchy phrase. And the suspicion is that that is what's going to be used to wrap in disinformation on perhaps some of the grounds that you mentioned before, public health, etc. As we saw very strongly, the government was already using formal and informal channels to, as they would say, work with Facebook and others in order to minimize disinformation about COVID, about vaccines and so on. So that's one route in which politicians will be looking to exercise control over disinformation. I say that, subject to not knowing as yet what might be listed in that section about priority content that's harmful to adults. However, the other way in which it could potentially be tackled is by way of existing laws, and most damagingly of all, some proposed new criminal offences, new communications offences that concern content that is false and that could potentially cause harm to people by essentially misleading them or telling them untrue information. And because that will be a criminal offence, then the duties on platforms to take that down are much stronger than if it was simply considered to be more generically harmful. And this is a brand new offence that is being brought in through this bill, so we don't really know how it's going to work in practice, and it's one of the more worrying elements.
Indeed. And I mean, as you well know, Victoria, an interview that I published on this very channel during one of the lockdowns, I can't actually remember which one it was, but that proved quite controversial, and I was slapped with one of these non-crime hate incidents against my name. I wonder what kind of new legal question marks, like that Orwellian sounding non-crime hate incident, are going to actually be brought about thanks to this bill. I recognise I'm asking you right now to sort of be a clairvoyant and predict the future, but where do you see the pitfalls of this bill coming into force with sort of gusto as far as the legal question marks are concerned?
Well, I'm glad you've raised that incident that you were subject to. I was nervous of doing so in case it was a bit sensitive. Horrific series of events there, and I think it's actually a really good working example of the kinds of things that will fall within the duties under this bill, and in particular because I assume we're talking about the interview with David Starkey.
Oh, absolutely, yes, yeah.
Which was alleged by some people, and indeed was investigated by the police, for one of the offences under the Public Order Act to do with stirring up of racial hatred. And that particular offence and a whole bundle of other offences under that same act are labelled under the bill as priority offences, which means they attract the heaviest duties of removal and filtering by search engines and by social media. Now, the interesting thing about the example of the offence that you were alleged to have committed is that under the statute concerned, there are a lot of protections built in for freedom of expression. And indeed, proceedings shouldn't even be instituted in respect of that offence. It couldn't come to court without the authorisation of the Attorney General. So it's a very, very high threshold for charges to be brought for that offence. However, Facebook don't need the consent of the Attorney General to take that content down. And in fact, they can't wait about, because if they are found to have left that content up by Ofcom for too long, then they will face fines and potential prison sentences for their management. So all of those protections that are built in to the law to protect freedom of expression and the rights of the individual will be completely short-circuited, because the platforms will act to protect themselves and can only act based on the bare information that they have in the post. The algorithms that will scan all this content won't be able to undergo all of those balancing exercises that finally ultimately were brought to bear in your case, and that no charges were brought. There was no case to answer. Facebook and Twitter and YouTube and Google won't have the time or the space to make all of those determinations. They will just have a much lower threshold for asking, does this look like one of these offences? Yes, it does, take it down.
Indeed. And I think there are two questions I have from that then. If we consider, as has been the charge for a number of years now, that Silicon Valley tech giants have a left liberal bias, you marry that with a duty to remove content that is quote unquote harmful, so there will be I think a more, well, certainly a lightning pace, shall we say, approach to removing any content which could mean they fall foul of these massive fines. It has to be said, gargantuan fines,
It will
and
be tens of
crippling.
millions potentially.
Yeah, and of course these the criminal sanction perhaps as well. You marry that with the left-leaning bias that a lot of people accuse tech giants of having. Surely no conservative-leaning content, no anti-lockdown content, no, it could be pro-life content. I don't know, there are a whole list of things that might already be against the worldview of a tech giant or an official working for Google or Facebook or Twitter, whatever. Surely this is a recipe for disaster for the people on the right. And then you consider that the Conservative Party are the people pushing this through. Just what's going on? Do you agree with those sentiments, or am I being a conspiracy theorist?
I agree to a certain extent. So I definitely find it rather baffling that a Conservative government would get involved in something quite aside from the principles of the matter. Tactically, building up a power base in a regulator like Ofcom seems to me to be a bit of a tactical mistake for a Conservative government. I don't think necessarily that this will work towards having a particular bias against conservative or right-wing perspectives. I think what it will do is that it will simply reinforce the prevailing collective liberal elite worldview, if you like. And so heterodox or dissident views from any perspective will be prejudiced by this, because they are the kinds of things that are most likely to be seen as being harmful or as being disinformation, if that's the way the eventual regulations go, and of biting on all kinds of these new communications offence that are based on psychological harm, or the existing public order offences that are based on insulting and abusive words. So I think, yes, heterodox conservative views will be prejudiced, but so will heterodox and dissident views from all different perspectives. But as I say, my main concern is that this is a big government solution that's empowering the communications regulator in a way that's quite Orwellian. And so both from a principles perspective and as you say, a tactical perspective, it's rather baffling that a Conservative government would be heading there.
Because on that tactical perspective, the revised legislation means that social media platforms, as you rightly say, will be required to deal with categories of legal but harmful material that Parliament, it is Parliament defines, right, and not the Secretary of State.
Well, the Secretary of State will define it, but it will be done by way of regulations that will be put before Parliament.
I see.
Like in the statutory instrument, which is, I mean, there's a little bit of accountability there, but I think we all know that statutory instruments usually just get waved through without too much difficulty.
Exactly. So if you imagine then that 2019 had gone differently and Jeremy Corbyn had been elected with a massive majority, do we assume that Miss Dorries, the Secretary of State, would be so sort of sanguine about a bill that hands parliamentarians the ability to determine what speech is and isn't harmful? I mean, she's had a few controversial statements in her time, I'll tell you that much.
Well, she has, and you might have noticed, and your viewers might have seen that the civil liberties organisation Big Brother Watch did a little experiment where they set up some dummy accounts on, I think it was on Facebook and maybe on Twitter, and they got these dummy accounts pretending to be just average Joe members of the public, and they posted the exact sort of words or jokes that some politicians had made to test what Facebook would do with that content when it was posted by just a member of the public. And I think one of the posts that they took was a certain exchange that Nadine Dorries had, and I'm not going to repeat what she said on a family show, Darren, because it was rather spicy stuff. I think she was having a fight with James O'Brien, if I recall correctly. And when they put her words into a Facebook post pretending to be from a general member of the public, Facebook took it down. So because it was seen as breaching their community standards. So I think, yes, Nadine Dorries, as with everyone else here, needs to be careful what they wish for.
Yeah. What does that... We haven't really, I guess, described in layman's terms what the hell legal but harmful actually means, right? How do you define that?
Well, the new iteration of the bill has a new definition of harmful. The old draft bill that was in circulation last year and was scrutinised had a very wild definition of harm that lawyers were just tearing their hair out because it was so complicated, and really you couldn't have applied it in real life with any certainty. The new definition of harm is a bit better. It talks about psychological harm and distress, but the problem is with any definition, it's going to be quite subjective. Even if you try and say that it's an objective definition or an objective test, that content that could reasonably be considered to cause harm to a reasonable person, to cause psychological harm or distress to a reasonable person. There's really no easy way to put good, firm definition around that. And it's always going to be subjective in the eye of the beholder in reality as to whether something is considered to be harmful in that way, especially when it's linked to the ideas of suffering psychological harm and distress. Does that mean being a bit upset? Does it mean, suffering the much worse sort of consequences, sort of up to levels of PTSD that people can suffer as a result of a sustained sort of campaign of bullying and so on? It's a very amorphous concept. And again, let's always keep in mind that what we will be talking about in real life will be algorithms, and potentially a level above that, teams of human moderators sitting in a call center.
Well, that's right.
Who will have to scan vast amounts of content for certain tags that will trigger a sort of warning as to whether something is considered to be likely to be psychologically harmful or not. And that is really going to be quite an impossible task to do with fairness and certainty.
Yeah, because I mean, if any, really, what positive impact, if you had to say this, I'm pointing a gun at you now, Victoria. What positive impact could this bill have upon someone's life if you had to actually offer one? Let's imagine you're Secretary of State. What positive impact do you think this bill will have?
That's a very hard
Can you
question.
give one? Yeah.
So
do you genuinely believe it will protect children? Do you genuinely believe it will protect vulnerable people online, people from fraud and things like that? All laudable things.
Yes. So I think to put the government's case, they want to protect children. And there is no doubt that lots of children have suffered quite terrible consequences from their use of social media, whether it's being bullied, whether it's reading content about self-harm and suicide, or all of these terrible things that we know happen. However, from reading the bill, from reading the impact assessment that came with it, and actually from reading years worth of material by various committees who've been looking into this subject, I am in no way convinced that this bill will actually help to protect children, or indeed adults from experiencing these, this damaging or adverse content. For a start, I think the prevalence of this content is massively overstated. The Joint Scrutiny Committee itself that looked at this last year, the Parliamentary Committee, admitted that academic evidence shows that this harmful content is actually extremely rare. It represents significantly less than 1% of all of the content that's out there on social media. So the prevalence is overstated for a start. And then in terms of children, what really worries me is the idea that because the government is trumpeting this as making the UK the safest place to be online and protecting children, is that going to give the idea to parents that somehow the internet has been made safe and they can just let their children use their devices without supervision because the government stepped in and taken care of it? Whereas actually I think that's not going to work at all. And parents ultimately do need to take responsibility for supervising and monitoring what their children are looking at online and talking to them about what they're doing, who they're talking to. That ultimate responsibility has to rest with parents. And I am quite worried that there's going to be an adverse effect of building a false sense of security there with parents.
Yeah, to sort of go back a step on what we were talking about a moment ago before I asked that question about the positives. If you imagine being, yeah, well, quite the Leah Tom, it is Leah Thomas, isn't it? The swimmer who, if were I to be Leah, and I saw that you, Victoria, had sent out a tweet saying, actually, I don't think women's sports should have trans women participating in them. Would I be able to say, well, that's damaging to my mental health, that's harmful, and then have your speech limited, even have you perhaps kicked off one of these platforms? Just how far do you think the regulator's pendulum is going to swing in the opposite direction of people's everyday lives, of just having an opinion, right? Just average internet users.
Yeah, these are the kinds of case studies that I think we should be asking ministers to provide for us as a matter of scrutiny, and I hope MPs will be doing exactly that as this bill progresses through Parliament, asking very specific questions and working through these kinds of cases, because there have been cases under the law as it stands at the moment that have been quite similar to exactly that. We have heard many instances of gender critical women being investigated by police for engaging in debate about the issue of transgender rights and women's rights. Now, the Secretary of State, if she was here today, would no doubt say, no, we have dealt with that because we have made it clear that freedom of expression is also to be protected here. The platforms have to protect free speech. But unfortunately, the free speech duties in the bill are very weak. They are phrased in terms of having regard for freedom of expression and taking account the rights of free speech of individuals, whereas the duties to remove and filter content and run a system that does all of those things are strict duties backed with fines and criminal sanctions. So I'm afraid in reality, that kind of sort of scenario that you outlined is a real risk, that the content scanners, the algorithms, will be on a hair trigger for that kind of content that people with those kinds of protected characteristics could claim is harmful to them.
Jeremy Wright, the former Secretary of State, he has passed comment on this bill. He likes it, there's no surprise there. But the exemptions from the reach of the bill for journalism, right, which he says needs to be clarified to only exempt those who really are journalists. Now that got me thinking, Victoria, well, how does the state decide what is and isn't a genuine journalist, right? Isn't this going to have a chilling effect on press freedom in this country?
Well, I must admit, I haven't seen Jeremy Wright's comments, but I do know the parts of the bill that he is referring to. And there's a couple of issues that, occur to me immediately here, which is one, this bill is now essentially introducing press regulation by the back door. Because in order to have your journalistic freedoms protected, you have to meet certain criteria set out in the bill. Now, albeit the criteria currently are relatively light, but it is still the state laying down in law what constitutes journalism and what you have to do in order to have your journalistic freedoms respected, which is not something that should just be done offhand, sort of almost by accident or as a side effect of a bill that's trying to do something else. Now, secondly, even if you do meet those criteria for qualifying as journalism, how is Google and how is Facebook and Reddit or Mumsnet or any of the other thousands of technology firms that are in scope here, how are they going to recognize journalistic content when it's posted on the internet? There are thousands of journalistic publications out there in the world, hundreds of thousands, millions probably even. And so someone is going to have to come up with, again, is it going to be an algorithm? Is it going to be some kind of tag that journalists will be able to embed into their content in order to verify that they actually are journalists? It's to me, all of this is extremely problematic and in practice going to be very suboptimal for journalistic freedom. And I should add as well, the very fact that the bill includes specific protections for journalistic content, for news publisher content, and for something that it calls content of democratic importance, to me is an admission that everything else is actually at threat. Because if you have to build specific protections for types of content that you consider to be desirable, that to me is an implicit admission that all of the other kinds of content are going to be subject to censorship and infringement.
Yeah, good point. I mean, do you think ultimately then, with all of this being said, with all of the judgment that you passed on the actual specifics of the bill, is this country, are its people, one that still view freedom of speech as a key plank of any good, tolerant, liberal society? Do you think we're losing that fondness for free speech? Because were you to ask people, do you support this online safety bill? It does X, Y, and Z. I think overwhelmingly people would say, oh yeah, that sounds good to me.
I think you're probably right about that. And there's no doubt that the bill has very strong support in Parliament, across the House, and actually, across the media as well, which is rather strange to me. But in some ways, I suspect old media, the newspapers, consider this a way for them leveling the playing field against tech giants. But I think that's rather short-sighted of them, because I can't see a way that news publisher content and journalism is not going to be curtailed by this in practice too. And in terms of ordinary people who might be thinking about this, the idea of it being a way of protecting children and countering terrorism and horrific child abuse and child pornography is very appealing. And I suspect, even I would say, if it was a question of me being able to spout off freely about issues of gender and sex versus protecting children from abuse and exploitation, of course I would say I would rather protect the children, but I don't think it's a zero-sum game. And I think everything is being swept up here in ways that probably aren't in practice going to protect children. So we'll take all of the losses to free expression, but perhaps ultimately won't get the gains. And in a few years' time, if you ask people, do you miss the olden days of Facebook when you could have a really ferocious and robust debate with all of your Facebook friends, and you could watch videos of controversial people from America or people like Darren Grimes on YouTube, I suspect people might come to miss that and realize that actually freedom of expression is a value that we all benefit from.
How much is this sort of an attempt really to, I guess, well, it's just an attempt to make the internet quite a boring place to be, isn't it? It loses that what Nadine Dorries and others would describe as the Wild West element of the internet, but it loses that organic nature, right? It loses that flexibility, that freedom. Yeah, exactly. Yeah, and becomes quite a stale, clinical place to be.
Well, so this actually reminds me of another point that really occurred to me very strongly as I was reading through the bill and putting my technology lawyer hat on here. So much of the obligations that will be on the tech companies is going to be put this in your terms and conditions, make sure that you've explained this, tell users this, put this in your terms and conditions, give these rights. A lot of it turns on terms and conditions and informing people. Now, that all sounds quite nice, and of course, users should be well informed and empowered with the choices that they make. But I know in practice what this is going to mean is many thousands of words more terms and conditions for you to accept, many more pop-up boxes for you to tick as you work through the process of actually interacting online. In terms of those kinds of boring, burdensome pop-ups, this is going to be a bit like the GDPR all over again. And coming at a time when the government is trying to support innovation and support tech and the digital investment in the digital world in this country and make us a hub for investors and innovators, I'm afraid that it's going to be this bill is going to drive the exact opposite of that, and it's going to drive very poor user experience. You're going to have to verify your age if you want to access anything that isn't proactively oriented at children. So, any adult content, by which I don't mean, pornography and adult content in that sense. I mean anything that isn't actively made suitable for children. You're going to have to verify your age. You might have to verify your identity if you want to participate fully in internet discussions. So user experience is going to become really tedious, and you're going to have to put a lot more private information in there if you just want to keep up a similar level of user experience to what you have today.
Well, actually, I think that's a pretty depressing but good place to end our discussion today. I guess the final brief comment I would ask you to make, Victoria, is given that, as you say, this bill has massive support within the House of Commons, it's going to sail through, basically. What would your plea to parliamentarians be at this stage?
Well, I think, in fairness, there are a handful of parliamentarians in the House of Commons and in the House of Lords who are taking this seriously and who are worried about the free speech implications. So there is some hope there. I think all MPs need to do their duty of scrutinising and trying to understand this legislation and asking hard questions of the ministers in DCMS to explain themselves and put up these genuine sort of case studies of the type that we were talking about to try and work them out in practice. How is this going to work? There are a lot of very senior lawyers, former judges sitting in the House of Lords. They're really going to come into play with their experience and legal knowledge. So I have high hopes for their powers of scrutiny here. My hope actually, and I mean, it's a bit of a faint hope, is that actually the bill has become so long. It's 100 pages longer than the draft bill. It comes in at 250 pages. And it's so complicated, and it's now had so many different new things thrown in at it in response to lobbying and activism, I've no doubt, that it's become perhaps too weighty and is going to collapse under its own complexity if MPs do their job and scrutinise it properly.
Well, we shall see, right? We live in hope. This has hardly been a parliament that's been renowned for its scrutiny, is it? But we'll see. We will see. Victoria Hewson from the Institute of Economic Affairs, thank you very much for your time today.
Thank you.
Now, please do consider hitting that subscribe button and the notification bell if you enjoyed today's content. There's going to be lots more coming, and I'll see you next time. Thank you so much for watching this video. Reasoned is a grassroots organisation that's entirely funded by people like yourself. So if you're in a position to do so, please do consider supporting us by clicking the link to the side there.